Hi, I'm attorney Ben Schwartz, and today we have attorney Stephen Schwartz. Stephen is the founding partner of our law firm. He's my partner. He's also my father. And so today we're going to ask him a couple questions about his wills and estate planning practice. Dad, can you tell the folks, one question we have frequently is people ask who should be going to a attorney for drafting wills, for preparing estate planning documents. And do you need to be a millionaire, or is this something that everyone should go to an attorney to talk about?
I believe everyone should go to an attorney to talk about wills and estate planning documents. You don't have to be a millionaire, and in fact, you don't know what assets you will have when you pass away. People die, and they may not have much in the way of assets, or they may be quite wealthy and not know it. For example, I had in the early days of my practice, I had a client, or I had clients. It was an elderly couple, nice elderly couple. They came to me for wills, and I prepared them. They signed them, and about a year later, the wife returned to me and told me their husband had just passed away. And as the facts were related to me, I came to realize that this gentleman had died a wealthy man, but didn't know it. He didn't know he was wealthy. His father, who had quite a bit of money, had died a few days before he had. His father had been in a hospital in California, but they didn't want to tell my client, the gentleman who I represented, and who was also sick and in the hospital in Delaware, they didn't want to tell him his father was deathly ill because they were afraid it would upset him, and so he didn't know. His father died first, and because he survived his father, under his father's will, he inherited, and he died a wealthy man. If he hadn't had a will, then his estate would not have been controlled, would not have been distributed in the way that he wanted. And so it's important, even if you don't now have assets, it's important to provide for what will happen if and when you do. There are other important things that can be decided by a will that are not controlled by how much money you may have or assets you may have. For example, people with minor children, if they want to designate a guardian or a custodian to take care of the children upon their death, then the will is an appropriate document to name a guardian of the person and of the property of your minor children. So even people without assets, without hardly any money at all, may want to have a will so that the future of their children can be decided as to who the children are going to live with, who's going to have responsibility for caring for them. That can be decided in a will.
Here's another question for
Yeah.
you. Mm-hmm. When someone comes in and they have a consultation and they establish that relationship, what types of goals do you have, or what types of goals do they have for that relationship?
All right. Well, any attorney everywhere is going to have as a goal helping the client to determine how his assets should be distributed on death, and how his assets or how his estate should be administered after he passes away. Here at Schwartz & Schwartz, we have some additional goals that aren't always pursued by other attorneys or other law firms. We also make it a point to plan for managing a person's estate during his lifetime. For example, when we do wills, we typically do, along with the will, an advanced health care directive and a durable power of attorney. And when we do those documents along with a will, we do not charge a client additional for the advanced health care directive and the durable power of attorney. We cover that with the cost of the will itself. And I think it's important because those are very important documents, and it's always been our policy that when we do a will for someone, they ought to also have these other documents to provide for the necessary estate planning during their lifetimes. And it's an important enough document, or these are important enough documents, I should say, so that in strongly recommending them to clients, I've never wanted clients to feel like we were marketing documents to them, like we're trying to sell them something. So it was always our policy not to charge extra for those documents when we're doing a will. The Advanced Healthcare Directive is terribly important because it contains a medical power of attorney, so that if the client is unable to make his own healthcare decisions because he's disabled, incapacitated, then the person he names as agent will have the authority to do that for him. And the Advanced Healthcare Directive also contains living will provisions, which will govern the circumstances under which a person will be maintained or removed from artificial life supports. So, for example, if a person is in a terminal condition, meaning he's about to die anyway, the person can specify whether or not he would want to be put on artificial life supports. And similarly, if the person is permanently unconscious, which typically means he's been unconscious continuously for 4 weeks and 2 doctors certify he's not coming out of it, then, and that's typically the flat brainwave situation, under those circumstances, the client can specify whether or not he would want to be maintained on artificial life supports, and the person can also specify under both those conditions, terminal or permanent unconsciousness, whether or not he would want to receive nutrition or hydration through conduits, meaning he can specify whether he'd want to receive food and water through tubes. These are terribly important decisions, and often family members have to try to deal with these situations, and frequently family members are not in agreement with one another as to what the patient or the client would have wanted, and so it's important for the client to be able to decide these things while he's got the capacity, while he's able to do it, and the way he does it is with an advanced healthcare directive.
So this is something, we're talking about goals of representation or goals for a client. This is something that is typically a goal for the client, but really the goal is to make the decisions so that the client is not a burden on their family members. Is that what I hear you saying?
Well, not just a burden, but also so that we don't end up with conflict among the family members. And that's a real goal of ours in doing wills. Just to take it back to the initial question as to what our goals are in preparing wills. One of the important goals that I have always pursued, and then this office pursues, in helping people plan their estates, is to try to avoid circumstances that are going to cause conflict among family members. And it's often possible to draft a will that will predictably cause problems among the family members, create conflicts, and it's often possible to draft a will to avoid those conflicts. And I think an attorney has an obligation to do what he reasonably can to avoid creating problems, to avoid creating conflicts among family members. And that's a major focus of our estate planning too.
Very good. Last question. How come you look so good and I look like I'm working hard?
Well, somebody has to do the heavy lifting, Ben, and that's
There
you.
have it. So I'm attorney Ben Schwartz, and today I'm interviewing my father and my law partner, Stephen Schwartz. Thanks for watching the video. Please feel free to contact us if you have any questions or concerns.